question in terms of what's still alive and what's not. Is the disparate impact claim still alive, or is that no longer part of this case?
I think that is no longer part of this case, Your Honor.
No longer part of this case.
Yes, I don't believe there's proof in the record about disparate impact. So I would say that is no longer a part of the case. But what remains are retaliation, malicious harassment, disparate treatment claims under the Tennessee Human Rights Act. And respectfully, Your Honors, our complaint is that the lower court made an error in the dismissal of the case following a discovery sanction that sanctioned the plaintiff, Ms. Word, after she filed some discovery responses that simultaneously denied and objected to some questions about her work conduct. So the denial in the discovery responses was something to the effect of denied and objected, not reasonably calculated to lead to discovery of admissible evidence. Well, about a few months later, Ms. Word came into a deposition and promptly owned that those things should not have been denied. And these involved conduct at work where she had sent personal emails out and done some online shopping. Well, the defendant used these acts against her in a meeting later after she complained about discriminatory promotions practice by the Knox County clerk.
What's our standard of review in considering discovery sanctions?
I believe it's an abuse of discretion.
What makes this an abuse of discretion then? I mean, the meeting that the judge is essentially not allowing evidence as to is the meeting where these allegations are brought up, and she did not provide truthful responses in terms of denying. And what makes that an abuse of discretion?
Well, the way the court, ultimately what happened, the denial of this meeting triggered a problem with the statute of limitations, because this meeting happened on November 2 of 2015, about 5 days after something else that had happened. Well, the complaint got filed on October 27 of 2016. So when the plaintiff lost the ability to put the proof on about this meeting, where she was threatened by Mr. Arnett, the appellee, after making complaints about racially discriminatory promotions practice, her case essentially disappeared. And
there's a significant number of rationales that was offered by the trial court here in terms of ultimately granting summary judgment. I take it from your briefing that you essentially view the meeting, evidence as the meeting being eliminated, taken off the table, is the cornerstone under which all of those fall. That if you could use the meeting, then those grounds, is that, am I understanding correctly?
I think you've hit on it, Your Honor.
How do we though? I mean, there are a wide variety of explanations offered by the trial court. And how does this court connect up that the meeting is the linchpin for each of those? I mean, some of them you've made a very clear argument, let's say, in terms of, for example, continuous or continuing conduct. Some of them, the relationship may be a little less clear between how the evidence related to the meeting interrelates with the trial court's rationale, that particular rationale for summary judgment. So it seems like this court's being put in a position where it's having to figure out how does the meeting relate to that ground.
How does the meeting, is the court asking how does the meeting relate to prior acts of discriminatory conduct?
We have a summary judgment decision that is exhaustive in terms of the trial judge went through and had multiple rationales in terms of why summary judgment's being granted here.
Right.
Your brief here doesn't necessarily touch upon all of those tying together, interweaving. I mean, you've got sort of an overarching point, I take it, of the meeting's the key. We wouldn't have had summary judgment granted if we could use the evidence from the meeting. Some of those rationales I look at and I don't immediately see the connection between the meeting and that particular rationale for summary judgment. And I'm wondering if that's a problem in terms of, and the court's not really supposed to lawyer that particular issue. So if there are grounds where that connection's not clear, is that a ground that just stands?
Well, I think the meeting itself is critical in the whole course of conduct, which is what we would call it under the Booker case, the Supreme Court case, which does a great deal to explain what the continuing violations doctrine is under the THRA. And that last meeting would tie all those prior acts, those failures to promote people of color in the Knox County Clerk's office and to promote only white persons. That last meeting ties everything together. It also is standalone, Your Honor. It would save her statute of limitations, even if the continuing violations, our position is, even if the continuing violations doctrine does not apply, it standalone would have saved her statute of limitations. I don't think the trial court.
And the standalone would be as to, would that be as the malicious harassment and hostile work environment? Are those the claims that it would stand alone as to? Is there anything else that it would be a standalone claim as?
Disparate treatment, malicious harassment, hostile work environment. I think I've touched on them all. Racially, yes, sir.
I'm sorry, let me take you back. And maybe you said it and I just missed it, but it seems like you're talking about the results of what the trial court did, but I think the question I believe you were asked is, why was that an abuse of discretion?
Right.
We understand the results of what happened, what the trial court did, but why was it an abuse of discretion?
If the court accepts that the results were fatal, as they were, which, to exclude, I mean, not to be cynical, but there's a reason why these defendants wanted that particular meeting excluded, right? It led somewhere for them legally. It led them to summary judgment. So, and so your question is, why is it an abuse of discretion? Your Honor, given the outcome of, first of all, it's arbitrary. Why this particular meeting? We have corroborating evidence from the county clerk himself in his own deposition about the threats he made to Ms. Word during this meeting. It was arguably the most egregious conduct in the whole case. So it stands out as very important for this case. So to exclude the meeting in its entirety, the net result is summary judgment. I think that's...
Isn't the meeting connected here, though, by the subject matter of the meeting relates to the underlying allegations, issues related to misconduct in the workplace? I mean, isn't that the connection between the two? The meeting is where they were discussing properly or improperly, and the past conduct in the workplace for which the supervisor had objections as to the employee's conduct. I mean, isn't that the connection here of why that meeting would be?
I take Your Honor's point, and yet we have testimony from not only the defendant but from his human resources supervisor that corroborate I think the testimony from the defendant himself was significant enough to establish the misconduct and the discriminatory nature of that meeting, the harassing nature of that meeting. It was meant to threaten. And in that meeting, things that had happened with Ms. Word 3 years ago, which had never been brought up to her before, were brought up 5 days after she complained about racial discrimination in promotions in the office.
You have your time for rebuttal.
Thank you.
Thank you. We'll hear from the appellee.
Good afternoon. May it please the court. I'm excited to be here for the first time. My name is Rachel Harrison, and I'm here on behalf of defendant appellee Knox County, and my co-counsel David Wigler is here on behalf of defendant appellee Foster Arnett. We'll be splitting the time. I'll take 8 minutes, and he will take 7 minutes.
Okay, so 8 minutes and then 7.
I will
Okay.
be addressing issues 1, 2, and 6 of our brief, and we are here today asking this court to uphold the decision of the trial court. On appeal, Ms. Ward has waived multiple issues in her opening brief, and after waiver, this court should find that the only issues that remain are the harshness of the sanctions and the failure to promote claim. She fails to cite the relevant and determinative facts in the summary judgment record. This violates Tennessee Rule of Appellate Procedure 27A6.
The
and this
Tennessee
court's-
Supreme Court, in a series of cases, including de novo, seems to have taken a position that there needs to be some kind of prejudice or harm either to the administration of justice or to the opposing party. And it seems pretty clear what the issues that are being argued by opposing counsel are. What's the harm here, either to you as opposing counsel, your client in this case, I should say, or to the court in terms of considering those issues?
Respectfully, I disagree, Your Honor. I do not think that the brief sets forth the issues that she is arguing. She sets forth her disagreement to the harshness of the sanction, but she doesn't raise issues of how the trial court made error in its summary judgment decision. She does not appeal from several issues, and in fact...
Are we distinguishing here then between there are multiple bases upon which the trial court granted summary judgment here, right? I took your argument to be that essentially everything is waived. Are you taking a narrower position that the grounds that were not addressed are waived?
The grounds that were not addressed for several of her claims, I believe there's about 8 of them, were not raised as issue on appeal here,
Okay,
and
so
therefore she
those
is
you're
waived
asserting
them.
are waived. So you haven't seen the argument, so you can't respond to it, and that would be the harm that your client suffered.
Correct, and this is something that we briefed in our motion to strike the reply brief. In the reply brief, the plaintiff tried to cure her error and listed skeletal arguments of the laws at issue, but that's improper on a reply brief because we had already submitted our brief and we didn't have any opportunity to respond to it. I do want to point this court also to the supplementary authority that we submitted with this court of the Oaks v. Fox case, which was very recently decided by this court, and it found that on the appellant only appealed from the denial of the summary judgment, but the plaintiff filed an improper response, and so there was a motion to strike that response. And so on appeal, this court found that the only facts that it could consider were those from the summary judgment record, not the new factual allegations that the plaintiff raised on appeal. Plaintiff here cites to her complaint, which she expressly disputed in her responses to defendant's motions defendant's statement of undisputed material facts, and she cites to Foster Arnett's transcript, which was not entered into the record until after the summary judgment motions were granted and after final judgment was entered.
The briefing is more developed on issues such as continuing violation. Are you asserting that that's been waived also?
The continuing violations doctrine is a separate issue, and I know my counsel is modest, but that the Booker case is his case, and he is prepared to discuss that case for you. Okay. And so to continue with the deficiencies of the briefing, Ms. Ward completely ignores the defendant's undisputed material facts that the trial court expressly relied upon. And the fact that, and moving to our issue 2, the fact that she does not refer to the defendant's undisputed material facts tracks because she has failed to raise as an issue that the trial court erred in deeming those facts undisputed. Her briefing is deficient for this reason. On page 12 to
Part of
16.
the rejoinder from opposing counsel in this case is that the meeting here is such a linchpin that essentially, I think they use the description that's like having an arm tied behind your back or something in that, along that line. What are we able to glean from the record here as to the trial court's rationale for why this particular meeting, especially with an understanding that this was going to essentially be dispositive as to this case by tossing out that evidence? I mean, is the record clear in terms of why the trial court decided that was the appropriate sanction?
The record is clear, and I believe they stated that it was an ingredient missing to baking the cake, but that's not so.
What's the rationale then? I mean, what is the trial court's reason for this meeting? And reading through it, it seems like a lot of this was driven by confusion about whether there were GTLA claims or not GTLA claims, and that originally we had a particular sanction and then it changed. And what's the rationale for that ultimately led to the trial court deciding to impose the sanction which had this result?
Ms. Word committed perjury. Ms. Word answered discovery responses. Her interrogatories were signed under oath on April 6 of 2021. 15 months later, she sat for her deposition on July 20th of 2022. And at her deposition, she admitted that she perjured herself in response to those interrogatories. And so this entire time for 15 months, the defendants are working with false information. One meeting held on November 2nd, 2015 is within the abuse of, it's not an abuse of discretion.
Did the trial judge find that the defendants were prejudiced here? I mean, and she says, I denies that she was on the Victoria's Secret website, but I mean, the defendants are aware that she was, or she denies that she was emailing, but the defendants are aware. And did the trial judge make a finding here that the defendants were prejudiced in this case? That they were harmed? And there's a false response, but what's the harm that really befell in this case, and what's the real prejudice that occurred that justifies the result here?
The prejudice that the defendants experienced was dealing with inaccurate information throughout the case, and this is not the first time that this has happened. When this court addressed her first appeal, it noted that the pleading is not a model of clarity. The allegations are out of order and it doesn't necessarily flow from a chronological timeline.
That's not the same thing, though, as an inaccurate, as a false response, right? I mean, there's a difference between sort of ideal completing versus a false response in discovery.
Mm-hmm.
I know those seem like two different levels to me.
We provided the court with supplemental authority that supported dismissal, and Ms. Ward's counsel invited, if there was any error, then Ms. Ward's counsel invited it. We notified the court that dismissal of this claim may be fatal to her we were preparing summary judgment motions, and Ms. Ward's counsel adamantly disagreed and said that it was not fatal and that her claims would succeed.
Thank you. We'll hear from counsel.
May it please the court, I'm David Wigler on behalf of Foster Arnett. Just to go back and address a couple of the court's questions, off the top of my head, these are not all of the ones that we raised in our brief, but the constructive discharge claim, the malicious harassment claim, the hostile work environment, all of those were dismissed on the merits. They have nothing to do with a connection, a temporal connection through the continuing violations doctrine to a meeting. Nothing at all. Those were dismissed.
Do we have arguments before us with regard to those, or is this a sort of more of a Ramos issue in terms of it just hasn't been raised, and so this court has to affirm the ground if it hasn't been raised?
I believe because it wasn't raised on appeal.
Right.
And it also was not, since it wasn't raised on appeal, We haven't gone back and briefed where in the record those arguments may have been presented to the trial court. Is that the court's question?
Right, so if there's multiple ground rationales that are offered for summary judgment and something's not challenged or raised in the briefing, then that essentially there's no basis for the court reconsidering that ground. That ground stands, right?
That's right. And because they because they failed to appeal from dispositive issues, they can't show that any error on another issue affected the judgment.
Do those other rationales cover every ground, every theory in this case, or is there anything that is not covered by the grounds that you're saying haven't been challenged here?
The defects in the briefing as to the facts, failing to cite to facts from the summary judgment record, from the response to the Rule 56.03, that failure goes to the entire case. But except the harshness of the sanction. They did not appeal from the imposition of a sanction. They did not appeal from the finding of perjury. They appealed only from the harshness because it was case ending. And I want to emphasize, they invited any error in that. And their brief is very deceptive on that point.
What do we make here of, and the trial judge, initially, the trial judge said, I think it's too harsh for this case to be dismissed, summary judgment granted. And then the trial judge imposes a sanction, jury instruction, and then we have this GTLA confusion. And we end up with a sanction being changed that has the result that the trial judge thought was too harsh. And I'm still struggling a little bit what the trial judge's rationale was for that particular sanction. Why exclude all evidence as to this meeting?
It does not change the result, Your Honor. If I could jump to the continuing violations doctrine, I want to have a moment to explain that the result is the same even if you found an abuse of discretion, because the effort to link a meeting to discrete acts such as a failure to promote or a demotion, this court's case law, we cited 3 cases from this court holding that all of those are discrete acts with their own separate statutes of limitations.
Why wouldn't harassment or hostile work environment survive as a standalone with regard to just the meeting itself?
Because there was no appeal from the substantive rulings on those issues. Harassment has to be severe and pervasive. One meeting does not substantively satisfy the standard. And
right.
There were 11 months, they ignore this in their briefing, but there were 11 months between the time of that meeting and the time of her resignation. This goes also to the constructive discharge claim, and the reason it was dismissed on the merits. There were 11 months of perfect behavior. There was no conflict whatsoever. She didn't even see Mr. Arnett for 11 months before she resigned, and in her resignation letter stated that the last 8 years of her employment had been wonderful. There was no constructive discharge on the merits. There was no malicious harassment. Malicious harassment was also dismissed on the merits because that cause of action requires a threat to injure person or property. There was no such thing in this case. And that's in the trial court's summary judgment ruling on the merits. They didn't appeal from that holding. So all that's left is this continuing violations doctrine that they hope they have to both convince you to overrule your prior cases on discrete acts versus continuing violations, and the Sixth Circuit's cases applying Booker versus Boeing to dismiss these as discrete acts, to treat such matters as discrete acts. They have to ask you to overrule that. They won't even address those cases. They haven't asked you to overrule that. Under Rule 11, they had a duty to inform the court of contrary authority and ask the court, if they wanted to raise that issue, they had to ask this court to change the law. And that could have been done professionally, but instead they've ignored the law. And the trial court entered Rule 11 sanctions partly on that basis. In addition, on the basis of their responses to the summary judgment statement of material facts. And if I could just spend my last minute, paragraph 12, this is at volume 6, page 1006, and this is their response to several statements of material fact. The first one is number 12. Plaintiff has no evidence that a practice of discriminatory demotions, reassignment, or reduction in pay for black employees continued after October 27, 2015. And the citation is to plaintiff's response to the defendant's first set of interrogatories. So that was under oath. They told us they have no such evidence, and that's the citation to this statement. They dispute what they said in their interrogatory response. They dispute this as written, and they say defendant's discriminatory practice of intentionally not posting positions so they could be awarded to Caucasian employees either through promotion or reassignment without their having to apply for the position continued until plaintiff left. And the trial court, you will see, wrote not responsive and circled it on the document in the court's record. The next one, plaintiff also alleges that Knox County failed to promote her because of her race. That's undisputed. But number 14, plaintiff alleges that in September 2014 and March 2015, the Knox County clerk, Arnett, and Knox County hired 2 Caucasian male supervisors, identified later in the complaint as Travis Adderhold and Will Johnson, citing the complaint, quoting the complaint. That's what the complaint says. The response is disputed as written. They were not hired because they did not go through the required Knox County hiring policies. Now that is sanctionable conduct, to dispute something you've alleged in your complaint that they were hired on those dates outside the statute of limitation, to dispute it.
Counsel, your time's expired.
Thank you.
Thank you. We'll hear from the appellant and rebuttal.
Thank you. Your Honors, I sometimes feel a little bit like Alice in Wonderland trying to respond to the appellee's arguments, because what we are complaining about ultimately is the trial court's discovery sanction, which resulted in summary judgment. I mean, that's the end result. And however you want to parse this out, that sanction was not justified, and it was arbitrary, and even at one point it was described as too harsh by the trial court itself. The trial court, I think, and the parties were for some little amount of time very confused about which claims were still alive in this case. And the appellees, defendants, used that confusion to their benefit. They actually they sought to have the sanction of a curative jury instruction. They sought to have that sanction changed to just the wholesale excision of this November 2, 2015 meeting. Yes, sir.
I'm not sure I understand. Is it your position that, assume, first the question, that we find that there was no abuse of discretion as to the sanctions? Was summary judgment proper, or are you still contesting that, still arguing that summary judgment would still be improper?
Well, Your Honor, there's another argument and we have made it in our brief, which is that the failure to cure the problem didn't end with each discrete act of not promoting non-whites. That it really ended when a new policy was instituted by the Knox County Clerk's Office, which was later, much later. So that's an alternative ground on which this case could be reinstated.
All right, so your answer to my question then is yes or no. Would summary judgment still be inappropriate even if the sanctions were upheld?
The answer is no, Your Honor.
Okay.
Was any evidence offered as to disparate impact?
I'm sorry, say again.
Was any evidence offered as to disparate impact in this case?
Your Honor, we cede the field on disparate impact. I don't believe there was any evidence offered about disparate impact. But certainly there was evidence of three hiring or promotion situations where white folks were promoted in the ranks, and there was in direct contravention of the written anti-discriminatory policies of Knox County. These were not advertised. And Ms. Word put on the record, she put in an affidavit that she would have applied for these jobs if she had been given the opportunity. I also want to point out this is the THRA may not be popular right now, but it's a statute that is to be liberally construed, as our Supreme Court has admonished, and that sanctions, Rule 11 sanctions in this case, are totally inappropriate. Where you have an attorney acting in good faith, seeking to move his client's case to trial simply to get her day in court. That's really all we're here asking for, is that Mona Word be given her day in court in Knox County Circuit Court or Chancery Court. There's the judge was. The judge never explained why, even though he had changed the sanction to take the meeting out and exclude evidence, he never explained why once it became clear that you could have a jury trial in this case, why didn't he revisit the issue of that very, very harsh sanction? A sanction he himself called harsh. That abuse of discretion came in. Ms. Word's behavior did not merit that sanction. And even if it had, there was corroborating evidence about that meeting that darn well should have come into proof. And that was excluded as well. And that was wholesale, and it was arbitrary, and it was a mistake. And I believe it resulted, and I know the appellee talks about the summary judgment statements, but all of those, to every one of them talks about October 27, 5 days before that meeting. They say nothing about November 2 of 2015. Because that's where the defendant took her in a room and threatened her and her church family. I think I'm out of time.
You are.
Thank you.
Court's thanks to counsel for both sides. We appreciate your arguments today and the briefs on this matter.